everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our content, please remember to subscribe and hit the notification bell. It helps the channel grow. For today's situation, we're dealing with Part B in the ongoing Department of Justice, State of Missouri dispute between the Second Amendment Preservation Act. In this situation, the State of Missouri passed a law that prohibits the State of Missouri from helping the DOJ, and the DOJ is sad. And now Missouri wants to write a response back, explaining why you can be sad. So we're going to read this letter from the Attorney General of Missouri, see what it has to say. Well, let's get started with this. From the Office of the Attorney General, Eric Schmitz, to the Assistant Attorney General of the Department of Justice. Dear Mr. Attorney General, the right of the people to keep and bear arms is essential to the preservation of liberty. Missouri provides the nation's highest level of protection for the right to keep and bear arms. Debatable. Recently, Missouri enacted this protection through the Second Amendment Preservation Act. Your letter purporting to ask for clarification of this important legislation, which was purposely leaked to the news media, is riddled with a misunderstanding of law and falsehoods. We will not stand by when the federal government tries to tell Missourians how to live our lives. Missouri is not attempting to nullify federal law. Instead, Missouri is defending its people from federal government overreach by prohibiting state and local enforcement from being used by the federal government to infringe our rights. You can't use our apparatuses. Non-commandeering doctrine. We must remind you that our liberty is safeguarded both by the right to keep and bear arms and by power reserved to Missouri under the 10th Amendment and basic principles of federalism. Rights protected by the Second Amendment, and the 10th Amendment are woven into the fabric of our country. True enough. The founders viewed the right to keep and bear arms as a natural right that was inalienable. The right to bear arms predates our written Constitution. It sure does, because that's why it talks about the right to keep and bear arms. It's a right that predates the Constitution. It's the right. And the Second Amendment text indicates that it's not a right granted by the Constitution. Yeah, it's a right that's reflected because it's pre-existing, the right. It descends from our English heritage, an abuse of Stuart kings who selected militias loyal to them to suppress political dissidents, in part by disarming their components. The Glorious Revolution has given rise to the Bill of Rights, which grants subjects which are Protestants may have arms for their defense, suitable for conditions and allowed by law. At the founding, the colonists understood the right to bear arms as a natural right of resistance and self-preservation, held by all Englishmen, citing Blackstone's commentary. Thus, when King George III attempted to disarm the colonists, it prompted outcries he was violating the English rights to keep and bear arms. With this historical understanding, the founding generation enshrined the right to keep and bear arms in the Constitution and laws. Americans understood the right of self-preservation as permitting a citizen to repel force by force when the intervention of society in his behalf may be too late to prevent the injury, citing Heller, which is quoting Blackstone. The inherent right of self-defense is central to the Second Amendment right. The Supreme Court's survey of those provisions shows that by 1820, 9 states expressly guaranteed the right to keep and bear arms in defense of themselves or the citizens and the state. Justice James Wilson observed that Pennsylvania's right of citizens to bear arms in defense for themselves and of the state recognized the natural right of one's person or house. The home is special. The widespread adoption of a citizen's right to self-defense is strong evidence that is how the founding generation conceived of the right. Of course, self-defense has to take place wherever a person happens to be. In some circumstance, a person may be more vulnerable in a public place than his own home, citing Peruta versus California. Nice citation. From Justice Thomas's dissent for taking certiorari, which was quoting Volokh, who is an interesting law professor to be sure. Early court decisions interpreting the provision recognized an individual right to keep and bear arms in self-defense, whether public or private. In Missouri, a jury instruction that the people's right to bear arms in defense of themselves cannot be questioned could not possibly aid the jury because it was known to every juryman the right to bear arms is defense of ourselves. That's interesting. We're not going to give the jury instruction because every juror already knows it anyway. That's kind of interesting. A Louisiana court commented that the Second Amendment is calculated to incite man to a manly and noble defense of themselves, if necessary, and of the country. A Georgia court struck down a statute prohibiting open carry as depriving citizens of a natural right of self-defense or of his own constitutional right to keep and bear arms. The Nunn case emphasized that state legislatures lack authority to infringe on the right to keep and bear arms in self-defense. Holding the right is too dear to be confided to the Republican legislature. That's small r Republican. Our opinion is of any law, state or federal, repugnant to the Constitution and void, which contravenes this right. originally belonging to our forefathers, trampled underfoot of Charles I and his two wicked sons and successors, reestablished by the Revolution of 1688, conveyed to his land of liberty by the colonists, and finally incorporated conspicuously in our own Magna Carta. That's a lot of there's a lot of history and verbiage there to just like pwn the DOJ. Like, let me give you a history lesson about the right to keep and bear arms since you guys don't seem to understand it. That's pretty epic. The founders recognized that the right to keep and bear arms, not the government, is the citizen's first line of defense against physical attack, particularly when the government doesn't have a duty to protect you in particular, as we have learned many, many times. Thus, the right received its greatest emphasis during times in our history when the government could not be trusted to protect citizens' personal security. For example, anti-slavery advocates routinely invoke the right to bear arms for self-defense. One such advocate wrote that the right to keep and bear arms also implies the right to use them, if necessary, in the self-defense. Without this right, used to guarantee would be hardly worth the paper it consumed. Reflecting this recognition, Congress enabled the Freedmen's Bureau in 1866. The law stated the right to have a full and equal benefit of all laws and proceedings concerning liberty, security, including the right to bear arms, shall be secured and enjoyed by all citizens without respect to race or color or a previous condition of slavery. Because they recognized the government could not always be relied upon to protect the personal security and prosperity, the post-Civil War generation emphasized that the right to keep and bear arms was essential to the preservation of liberty. In the aftermath of the Civil War, the use of firearms for self-defense was often the only way black citizens could protect themselves from the mob violence. One writer emphasized that freed slaves have the same right to own and carry firearms as other citizens. You are not free, but citizens of the United States, and such, are entitled to the same provisions guaranteed to other citizens. All men, without distinction of color, have the right to keep and bear arms for families and themselves. So again, going back to some originalist history, since the DOJ doesn't appear to understand how the right to keep and bear arms is understood throughout history on a very basic level, right? So we can get into nuances about like what kinds of arms, to be sure, or things like that, or what manner of bearing arms. So the right to keep and bear arms, we could have discussions about what ways about keeping. How would you keep them? Or what methods of keeping are constitutional? Or what restrictions on keeping might be constitutional? We could have discussions of nuanced points there. Or the same thing with like the bearing. What kind of arms? Where? In what manner? By whom? Under what conditions? Under what qualifications, if any? Do you have to have some sort of, established ability to establish by law or something? Or you could have all kinds of fun, nuanced discussions. But we're well past that because we're at a very basic level of you have a right to defend yourself. So we're pretty simple, pretty low level here on Second Amendment land. We're not discussing the finer points about what kinds of weapons, where, by whom, under what conditions, time, place, manner restrictions, etc. and so forth. We're under, you have a right to have some kind of firearm to protect yourself. So we're kind of at the basics. Yeah. Based on its original meaning, the right to keep and bear arms backstops the liberty of a republic, since it offers a strong moral check against usurpation and arbitrary power of rulers, and will generally enable the people to resist and triumph. The people's right to self-defense was so well regarded that Hamilton dismissed the threat of Congress raising a large army while there's a large body of citizens who will stand in defense of their own rights. Cute. Missouri is proud to have the most expansive protection for right to bear arms anywhere in the United States. Debatable. Missouri's Constitution has expressly protected the right to keep and bear arms since adoption in 1820. The Constitution of 1820 provides Missourians' right to carry and bear arms themselves, and the state cannot be questioned. Missouri expressly reaffirmed and readopted this right in its constitutions of 1865, 1875, and 1945. Moreover, Missouri repeatedly expanded the constitutional language protecting the right to keep and bear arms, making it even more robust. Article 2, Section 17 of the Constitution of 1875 expands on the language of 1820 by explicitly stating the right to keep and bear arms extends to self-defense of one's home and property, as well as to one person's. The right of no citizen to keep and bear arms in defense of home, person, and property, or aid of the civil power, when therefore summoned, shall be called into question. Most recently, in 2014, an overwhelming majority of Missourians voted to expand the constitutional right even further. As stated in Article 1, Section 23, the right to keep and bear arms includes the right of firearms in defense of one's home, person, family, and property. These rights to keep and bear arms in self-defense are unalienable. Any restrictions on these rights is subject to strict scrutiny. The state of Missouri shall be obligated to hold up these rights and shall under no circumstance decline to protect against their infringement. The Second Amendment Preservation Act advances the right to keep and bear arms enshrined by the founders of the federal and Missouri constitutions by protecting law-abiding Missourians against unconstitutional gun taxes, confiscation, and control. It is the proud boast of our democracy that we have a government of laws and not of men. Citing Morrison. Great case from Scalia. We've covered it before on my channel. Fantastic opinion from Scalia. The framers of the federal constitution viewed the principle of separation of powers as absolutely essential guarantee of a just government. Yeah, so separating power, checking power, was one of the constitutional guarantees, the structure of the Constitution. Without a separate structure of powers, our Bill of Rights would be worthless. As are many of the Bill of Rights of many nations of the world have adopted or even approved upon the mere words of ours. That's Scalia, and he said the same thing at testimony in Congress as well. It was a really, really cool testimony in Congress that he gave. And I don't remember, I think it was after Morrison was decided. But he said, the essential thing of the Constitution is not the Bill of Rights, but actually the structure, the actual structure of the Constitution of the Constitution, how it's actually constituted. And he said, what makes the Constitution brilliant is the separation of power. And he points out that you can go to bills of rights in Russia or China that have stronger protections than anything America's ever dreamed of. But the actual reality, not so much. Otherwise, it's just a parchment guarantee. It doesn't mean anything because it's just a piece of paper. So the actual structure of the Constitution is the most important thing. The separation of powers is what keeps America fundamentally free. Pretty good stuff, yeah. The purpose of separation and equilibration of powers in general is not merely to assure effective government, but also to preserve individual freedom. While separation of powers may prevent us from righting every wrong, it does so in order to effect that we do not lose liberty. So we have constrained government power, which might prevent it from doing what we need, but also prevents it from doing harm to us. The federal system rests on what might seem a counterintuitive insight. Freedom is enhanced by the creation of two governments, not one. Federalism secures the citizens the liberties that derive from the diffusion of a sovereign power. Yeah, as the Supreme Court once wrote, the atom of sovereignty was split, which might have been a uniquely American concept. That you can actually split a singular thing into distinct components. Federalism protects the liberty of all persons within a state by ensuring that laws enacted in excess of delegation power cannot directly control their actions. Federalism enhances the opportunity of all citizens to participate in representative governments. By preserving room for experimentation in states, federalism also supports policy innovation that can address many of society's most pressing problems. Likewise, the 10th Amendment directly limits federal government's ability to shift the balance of power away from the states. The principles of limited national powers and state sovereignty are intertwined. Impermissible interference with state sovereignty is not within the enumerated powers of a national government, and action that exceeds the national government's enumerated powers undermines the sovereign interests of the states. The Constitution of the United States created a system of dual sovereignty, in which states retain a residual and inviolable sovereignty. This is citing Prince, which is the go-to case dealing with preemption, or commandeering. So that is the case dealing with commandeering. In that particular case, it dealt with the possession of firearms near schools. And the Supreme Court, for the first time, I think ever, since they invented interstate commerce from Wickard, they finally found a limit. They finally found one. I think Prince was the first time ever they found a limit. And they said, yeah, it goes too far because you're trying to encroach on state territory. And the reason was because you're trying to control state level apparatuses, and you can't do that. So yes, the states retain a residual and inviolable sovereignty. The states are sovereign. The federal government is sovereign. It's complicated. You're a citizen of the federal government and of the state. It's complicated. But that's okay. We can do complication. We can hold multiple thoughts in our head at once, right? The framers rejected the concept of a central government that would act upon and throughout the states, and instead designed a system in which the state and federal governments would exercise concurrent authority over people, who were, in Hamilton's words, the only proper objects of the government. The preservation of the states and maintenance of the government, as much within the design and care of the Constitution as the preservation of the Union and maintenance of the national government. The Constitution and all of its provisions looks to be an indestructible union, composed of indestructible states. Just as the separation and independence of the coordinate branches of the federal government serve to prevent accumulation of excess power in any one branch, a healthy balance of power between the states and federal government reduces the risk of tyranny and abuse from either front. So yeah, because the states and federal governments vie for power and control, it prevents either one from having too much, just the way the branches are split. So power checking power. State legislatures are not subject to federal direction, citing Prince. Yep, that is the baseline. Yeah, state legislatures are not subject to federal direction. Anti-commandeering. The federal government may not compel the states to implement, by legislation or executive action, federal regulatory programs. Exactly correct. The federal government may not compel or direct the state, its governments, and its apparatuses to enforce federal law. The federal government can do it themselves. If they can get the states to cooperate, that's fine, but they can't make them. Yep. The federal government has been down this road before on a gun issue, so it should know better. That's the Prince case. In Prince, the Supreme Court held that certain interim provisions of the Brady Handgun Violence Protection Act, commanding state and local law enforcement officers to conduct background checks on prospective purchasers and perform certain related tasks, violated the 10th Amendment. The federal government wanted state and local law enforcement to conduct background checks or make them. No. Guided by text, structure, history, and original public meaning, the court aptly observed that the extensive mutual assistance the state and federal government voluntarily provided to each other in early days of the Republic rests on there being consent to this cooperation. The states and federal governments usually get along pretty well, but it's based on consent. Thus, without consent of the states, the court explained that Congress could not impose those responsibilities. It was Hamilton's view the federal government could direct the officers of a state. The view had no clear support in Madison's writings, or as far as we're aware, text, history, or comment. So if Madison wanted this, he never wrote about it, so probably didn't. That was because the framers expressly chose a constitution that confers upon Congress the power to regulate individuals, but not states. The United States Congress can pass laws that reflect individuals because they are citizens or they're residents of the United States. So it is fundamentally within the national sovereign control to direct the individuals. But it can't commandeer state-level authority. The Constitution thus contemplates a state government will represent and remain accountable to its own citizens. Accordingly, the state of Missouri has every right under our system of government and the 10th Amendment to place limitations on what state and local officials may do. Absolutely correct. The Department of Justice has identified no conflict with federal law from the Second Amendment Preservation Act's restrictions on state activities and hiring practices. Indeed, any such conflict would raise concerns. The federal government was unconstitutionally commandeering Missourians and the state government. Right. So, there's no conflict here. You know, we're not trying to impose on the federal government or its officers or agents. We don't want to hire particular people. We don't have to hire anyone. We're discriminating on a non-protected reason. You know, so there's no conflict. And if there was a conflict, the conflict would suggest you're the ones in breach, not us, because of the anti-commandeering doctrine. Quite right. The Department of Justice's June the 16th, 2021 letter also direct conflicts with its own policy towards sanctuary cities. Yeah, so the Department of Justice has no problem with sanctuary cities when it comes to immigration, which is the exact same concept, right? Sanctuary cities are fundamentally the state and local officials saying we won't cooperate with federal immigration law. On the first day in office, President Biden rescinded President Trump's executive order that prohibited federal grant awards to sanctuary jurisdictions that refused to cooperate, which might fully be legal, right? The federal government doesn't necessarily have to provide support and aid to every state and citizen equally, and can certainly make it contingent on cooperation. So the Trump administration said, oh, we're not going to give money to places that refuse to cooperate with us in enforcement. And Biden rescinded that. In April, the Office of Justice Programs reportedly repealed the Department of Justice policy that required recipients of law enforcement grants to cooperate with U.S. Immigration and Customs Enforcement as a condition of funding. Right? So that's normally how the federal government gets states to do stuff, with money. Because states go, yay, money. They like money, just like all of us do. So the federal government, under the Trump administration, said, okay, we're not going to give money if you're not going to cooperate with us on immigration. And, as long as it's, it has to be compartmentalized. It can't be all the federal money or you run into a coercion problem. But as long as it's, targeted to the programs in place, it should be fine, right? There's money available for these programs if you cooperate. If you don't cooperate, then you don't get the money because you're not within the program. That's probably fine. So, but the Biden administration apparently said, oh, we'll give you the money no matter what you do. So, it's not much of a bribe if you're just going to give them the money anyway. It's just a gift. President Biden and the Department of Justice have decided to reward states and cities that refuse to cooperate with enforcement of constitutional immigration laws that protect our citizens against foreign threats. But now they attack Missouri for refusing to cooperate with unenforcing unconstitutional gun confiscation. You can't have it both ways. Pretty much true, right? You can't like pick and choose on these kinds of principles. Like, can states and cities refuse to enforce federal law or not? It's like, well, they can refuse to enforce the immigration law. In fact, we'll give you money. But they can't refuse to enforce the Second Amendment law. That doesn't make any sense. In an interview with Anderson Cooper in August of 2019, then candidate Biden confirmed his desire to confiscate guns. Cooper, so to gun owners out there who say, well, Biden administration means they're going to come for my guns. Biden, bingo, you're right if you have an assault weapon. The fact of the matter is they should be illegal, period. Yeah. Your letter of June the 16th, 2021 provides no confidence the Biden administration has repealed or retracted or retreated from this radical anti-gun position. Indeed, your letter expressly endorses the view that federal laws authorizing confiscation of firearms from law-abiding gun owners would be constitutional and valid. We do not share your radical view that federal law may effectively cancel out the fundamental liberty equally guaranteed to the Second Amendment and Missouri Constitution. The Second Amendment Preservation Act protects Missourians from such attempts to keep and bear arms. Missouri's Constitution requires the state of Missouri to uphold the right to keep and bear arms and under no circumstances decline to protect against infringement. We will carry out our duty to defend Missourians on the right to keep and bear act. We will fight tooth and nail to defend the right to keep and bear arms protected by the Second Amendment and the Second Amendment Preservation Act, and will not tolerate any attempt by the federal government to deprive Missourians of that civil right. Signed by the governor and the attorney general. Thus, that brings us to the end of the discussion of the Second Amendment Preservation Act in Missouri. We have covered the DOJ's letter and the response letter. And so now I suppose the Department of Justice has to decide if they want to sue for some sort of declaratory relief, which might be hilarious. Because it seems to me that Missouri is well within the bounds, based on my understanding of the law. So Missouri cannot prohibit federal law enforcement from undertaking its duties. It can't impose any sort of restrictions or penalties or tax or in any way prevent any federal level officer from enforcing the federal law. That would include the U.S. Attorney. That would include federal grand juries. That would include, Department, the ATF, DOJ, FBI, anyone else for that matter. So if they want to go enforce the federal law, go nuts. But it's our state level officials. We don't have to cooperate and we don't want to cooperate. We are in a position where we say, we don't want to be on these task force anymore. And we're going to wait until August to put it in place so people can make sure to, get out of the way. But after that, we don't want to play anymore. And so you can enforce the law if you want. We're just not going to help you. And if we're not going to hire your people, we don't have to. So, yeah, that seems fine. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.